Hello, everyone. Welcome to week 6. And so we're now in week 6. We're pretty close to completing the term. In this lecture video, I'll be talking about conciliation, which is one of the more common and one of the oldest formal alternative dispute resolution processes, going back as early as the 1900s, a few years after the Federation of Australia was created by the states. And in this particular lecture video, what I will try to do is to provide an integrative approach so that we could actually examine conciliation in the context of the other alternative dispute resolution processes that we have previously discussed, such as negotiation, mediation, and arbitration. And what I will do is to actually try to draw and highlight some differences and similarities across the 4 types of alternative dispute resolution processes that we have covered so far, and provide an explanation as to the context by which conciliation is often used. And in doing so, what I intend to do is to use a framework that I have created. So a framework essentially provides a guide or a way by which we could understand certain concepts to simplify things. And in looking at that framework which I created, what I will do then is to actually examine the other alternative dispute resolution processes that we have discussed. And I will highlight issues about, why a particular alternative dispute resolution process is often preferred, what the drawbacks might be, or the value might be in undertaking that particular ADR process. I shall also then highlight concerns about power. We've often heard about, the power mode and the empowerment mode. I shall also cover issues about natural justice, which will be pretty relevant to the ADR process of conciliation. And so on completing, no, I said the tutorial. So on completing this lecture podcast, so lecture learning outcomes. So in completing this lecture, you should be able to discuss and explain the process of conciliation, the similarities and differences between conciliation and other types of ADR, the role of the conciliator, and the uses of the conciliation process. So let's begin. So this is the framework that I have created, and you will notice that it begins with a dispute. If there is no dispute, there is no reason for people to negotiate. There is no reason for people to go to court, for example, or some tribunal. Now, we look at dispute broadly, in the sense that this could be a dispute between 2 parties or several parties in relation, for example, to a civil or commercial transaction. But more broadly, as we see, as we look at the conciliation as an ADR, we notice that the dispute may often be in terms of a person or persons who are aggrieved by an actor. This can be in the form of a complaint with the Anti-Discrimination Commission or with the Human Rights Commission. In that case, there are individuals who are aggrieved by the actions of another. This is distinct from those instances where there is a dispute between 2 parties, such as, for example, that there might be a person who asked a trader to fix a roof, and the roof wasn't done well. They have a dispute. But in that particular scenario, you actually both parties might say that you might say that both parties are actually aggrieved, in the sense that they might have different realities, in the sense that one person says this, the other person says that, but both are aggrieved because in the scenario I gave, the one who contracted with the trader to fix the house wishes to pay less, or wants remediation in relation to a job that was done. In relation to the trader wants to get paid. So both actually want something out of the other. In other cases, however, for example, when it comes to questions about discrimination, or questions about feelings that there has been a violation of human rights, or instances where there might be a complaint on the part of an employee that he or she has been unfairly dismissed. In that scenario, you have an individual who has a grievance, and the grievance is largely a result of another person. I make this type of scenarios distinct because, as we'll see later on when we talk about conciliation, there is a reason why conciliation is often the preferred way to deal with these types of disputes. But going back to the question of disputes in general, we would have known that when there is a dispute or a disagreement between individuals about an issue, the way to resolve that issue oftentimes is through negotiation. So the parties themselves who are in dispute negotiate, discuss with each other how to resolve a dispute. They know and they are aware that if the dispute can't be resolved by them, the possibility might be that they just abandon the dispute. So a buyer, for example, of a good that is damaged just abandons the desire to get a refund or get a replacement, or otherwise that individual might consider going to court or an administrative tribunal, such as the QCAT. Now, sometimes when you deal with disputes, the parties can do it themselves, or sometimes there might be family members or friends or relatives who get involved. In that case, there is still that informal network of individuals who try to help the parties arrive at an agreement or settlement in relation to their dispute. But sometimes the individual, at some point, they feel that they need to bring in lawyers. So there could still be negotiations between the parties using lawyers. And this is actually common and typical in relation, for example, to personal injuries or in relation to work cover or the attempt to seek compensation from an employer for a workplace injury. Lawyers would get involved. In relation to family matters relating to property settlement or parenting orders over children, lawyers could also get involved. But sometimes the parties feel that they need somebody who is impartial and objective. They feel that they can't resolve the dispute between themselves or among themselves, in which case they will consider mediation. Now, the value of mediation is that you have an independent referee or arbiter who just tries to mediate, be in the middle between two disputing individuals to try to get them, to reach a settlement. In more common terms, or in our common experience, when we were younger, and sometimes we'd end up having fights or disagreements with our siblings, we would ask, our parent or probably an older sibling to mediate. The parent in that case, because the parent or the older sibling is meant to be objective and impartial, just tries to get the parties to reach an agreement. But the mediator, the one in the middle, does not provide any advice as to who is right or who is wrong, but just trying to get the parties to talk to each other to reach a settlement. In a more formal context, that's what the mediator does, as we've previously discussed. What the mediator does is actually to get both parties to talk to each other for the purpose of reaching agreement. Now, we need to realize that even in the context of a mediation process, and when the mediator tries to facilitate a discussion between the parties for them to reach an agreement, there is negotiation that will be involved. The parties continue to negotiate with each other, but in doing so, the negotiation is done with the help or the facilitation of the mediator. We've also said that one of the best ways by which mediators become effective is that instead of focusing on the legal interests or the rights of the parties, the goal of the mediator is to try to uncover what the underlying interests might be of the respective parties in relation to their own assertion of their own legal position or their legal interest. What we learned before is known as interest-based negotiation, based on the book by Professor Roger Fisher and William Ury. So in a sense, we've now covered negotiation and mediation. And I'm gonna explain as well later on how as far as negotiation and mediation are concerned, it's a movement from facilitation to advisory, to a more advisory role, to a more adjudicative approach. We're going to be looking at that as well. The one thing we need to remember is that parties, oftentimes, when they have a dispute, try to negotiate towards a settlement because they want to avoid having to go to court. As we know, and from experience for some of us, having to go to court is an expensive process. It's fraught with emotions for a lot of self-represented litigants, and even those with lawyers. There's a lot of uncertainty and unfamiliarity with the court process. And the litigants, when they go to court, really have little control of how the process will unfold. They have little control about what the outcome will be. And of course, if we know that courts are experiencing a backlog in cases, it can take a while before courts hear a matter or resolve a matter. And so therefore, if individuals or disputants are hoping for a way by which a dispute might be resolved in a quicker manner, and where the outcome is something that the disputants could live with, then they will try to avoid going to court. But oftentimes, if negotiations fail, then they don't have any recourse. They go to the courts. Or instead of going to the courts right away, they might suggest, why don't we seek mediation first? And then if the mediation fails, they go to court. And of course, we need to realize that sometimes mediation might in fact be a critical component to a court process, in the sense that, for example, under the Family Law Act of 1975 Commonwealth, before an applicant can file an application for a parenting order, that applicant must first have tried to undertake mediation through a family dispute resolution practitioner. And that's there is a requirement that an applicant must submit what is known as a Section 60I certificate from a family dispute resolution practitioner that he or she has undertaken or attempted to undertake mediation with the other party, and that it has not been successful. So that would be a requirement before an application is permitted to proceed in the family court or the Federal Circuit Court. I also need to point out that under the new rules starting in September 2021, instead of having separate Federal Circuit, instead of having two courts, you have the Federal Circuit Court and then the Family Court. There has now been an amalgamation so that you now have the Federal Circuit Court and Family Court, but they're actually just one court now, which has been amalgamated as of September 2021. Now, the other point we need to emphasize before we talk about conciliation and arbitration is that even in those instances when after an individual, for example, after the dispute has failed and they go to court, the courts may still require the parties to negotiate or even seek mediation. So that's still pretty common. So even when proceedings have advanced to such a point that there is now a live case before a court, it is still common for a court to order the parties to negotiate or to reach an agreement between themselves, rather than waiting for the court to adjudicate on the matter. And the judges will often warn litigants that they may not be happy with the outcome if they leave it to the court to make a decision. And as well as reminding the litigants that if one of them fails, and of course there will always be a litigant that will fail because it's an adversarial win-lose situation, what will happen is that the courts will award costs in favor of the winning party based on the common law principle of costs following the event. And again, in many cases, therefore, maybe about 85% to 90% of cases which are commenced in court eventually are settled by the parties themselves, either through negotiation or mediation or even conciliation. And we're going to be talking more about conciliation in a short while. But The point there being is that there is a lot of interaction between negotiation of the courts or mediation of the courts, so that even, as I mentioned, even after a court proceeding has already been commenced, the courts may throw it back to the parties to negotiate, either by themselves or through or with their lawyers, or the courts may still refer the parties to mediation. The same thing with administrative tribunals. I'm going to talk more about administrative tribunals in a short while in this lecture video. Okay, so we've covered that. Now, we've also covered arbitration. We notice, you would notice that in the context of arbitration, if the parties fail to reach an agreement by negotiations, they would typically go to arbitration, although again, it's possible for the parties to negotiate, they mediate, and then they go to arbitration. But it might be more common that, if negotiations fail, if there's a legal demand made by one of the parties, such as the plaintiff, against a potential defendant, and they don't agree, then if they have a written agreement that in the case of, in the event of a commercial dispute, that the dispute be referred to arbitration, then they end up going to arbitration, which we've already previously discussed and covered in week 5. So I'm not going to go back, into the details, except what I'll do that when I move on to the other lecture slides. Okay, so moving on. Let's examine it. These different alternative dispute resolution processes in the context of power. So when it comes to negotiation and mediation, we will recognize that much of the power in terms of reaching a settlement or reaching an outcome is actually in the hands of the parties themselves. So when it comes to negotiation, it is the parties who have the power or are empowered to reach an agreement. They do it by themselves. No one compels them to reach an agreement. Even when it comes to mediation, the mediator has no power to compel the parties to reach an agreement. All the mediator can do is to try to facilitate a discussion between the parties so that they reach an agreement. So essentially, both negotiation and mediation as alternative dispute resolution processes are pretty much empowering to the disputants or the parties involved, because the parties themselves determine the outcome. We know, however, probably from experience or from our readings, that sometimes negotiations, or well, many times negotiations can fail. We know how negotiations can be difficult to do. We've probably had experiences ourselves where we tried to reach an agreement with another person, with a supplier or a trader, and sometimes it's difficult to reach an agreement. It could be in relation to a family law matter where there's a breakdown of marriage and there are questions about property settlement or parenting matters, and the parties have difficulty negotiating between themselves to reach an agreement. They can go to mediation, but again, the problem with mediation is because the parties are empowered to reach an agreement or not, then in terms of the certainty of outcome, it's pretty much uncertain, because if one of the parties refuses to reach an agreement, then there is no agreement. So in a sense, you might say it's empowering, but in a sense, it can also mean that there is little power in terms of really crafting or arriving at a resolution, because when one of the parties says no, then there is no agreement. So what then often happens is that if negotiations and mediation fail, there is that aspect of undertaking conciliation. But when it comes to conciliation, and I'm going to talk about facilitative, advisory, and adjudicative roles of the third parties involved. What is different with conciliation as an ADR process is that it typically doesn't proceed with the individuals themselves seeking conciliation. Okay, so When it comes to negotiation and mediation, these are ADR processes which often are in the hands of the disputants themselves to determine. Conciliation is different because conciliation often happens within the context of legal processes having been initiated or commenced in a court or an administrative tribunal. So that what this means is that the courts may actually compel the parties if the court feels that mediation is not the appropriate way, or that negotiation is not the appropriate approach to try to get the parties to reach an agreement. What the courts will then do is to order the party, or to refer the parties to conciliation. Or the administrative tribunal may also refer the parties to conciliation. The reason why the courts or the administrative tribunals might do that is that they would like a third-party individual, an impartial, objective person, to provide advice to the parties, focusing on the respective legal positions and their legal rights. As I will show later on, what the courts are doing would actually be two-pronged. One, by shifting the task of reaching an outcome through a conciliator, then the courts are trying to minimize the backlog, or the administrative tribunals are trying to minimize the backlog in the cases that they're dealing with. So instead of getting the courts to have to resolve the dispute, which means that there would have to be hearings as part of natural justice, the courts think that instead of waiting for 2 years or 3 years for a legal case to crawl through the legal system, it might be better for the parties to go to a conciliator who can provide advice to the parties as to their respective legal positions. It's still an advice, but it is an important advice because it comes from a third party who happens to know the law. And in a sense, it's kind of, when the conciliator provides advice as to the legal matter, it's almost like a warning to the parties that, this is the way I look at the case. And so therefore, if we go to a trial based on the evidence that you provided me, then chances are the courts or an administrative tribunal will decide this matter in this way. And so for that reason, on the basis of the legal advice I give you, what do you suppose? What steps can we take about a possibility of a settlement? So you'll notice that that is distinct from negotiation and mediation, which don't really focus on legal rights and legal positions. The mediator, as a facilitative person, ought not to focus on the legal rights and the legal positions of the parties. What the mediator does is actually to try to examine or uncover what the interests are behind particular legal rights and the assertion of legal positions. In relation to conciliation, however, it becomes more advisory, so that we might even say that the focus of conciliation really is to kind of advise the parties as to what the law is and what the relevant legal rights and legal positions are, in order to forewarn them that if they persist in seeking a legal outcome based on a determination or an adjudication by the court or an administrative tribunal, it may not be an outcome that they will be happy with. So in the facilitative process, on the one hand, you might say that the parties are totally blind to what the legal outcome might be if they have to go to court. When it comes to the court system, here it's the courts make a full determination as to what the legal outcome is. So instead of waiting for the point where the courts make a full determination based on the law, and here where the parties are totally blind in relation to negotiation mediation, where the parties are totally blind as to what the law is, there is a forewarning by a conciliator as to what the legal rights and positions are of the parties, so that they may want to consider their respective legal positions. Do they really want to bring it to the courts? And oftentimes, with a conciliator being there, the parties can reach an agreement. Now, let me just talk briefly about administrative tribunals. Okay. Yeah, let me just talk briefly about the context of conciliation, because I wanted to talk about tribunals. For simplicity, I've demarcated, these two areas as part of the courts and part of the tribunals. at the level of the federal system, for example, based on the Boilermaker's case in constitutional law, it wouldn't be permissible, for example, for a court to have non-judicial functions. So courts in general are not permitted to consider matters which do not involve a judicial matter, or where there is no matter involved. So courts in the federal system cannot be involved in resolving conflicts where there is no matter between parties, for example, based on the Boilermaker's case. So just quickly, what can happen is that in relation, for example, to a decision made by Centrelink or a decision made by the Australian Taxation Office, when a determination is made, if there is a complaint on the part of a taxpayer that that the decision of a tax officer does not appear correct, it will not be permissible for a taxpayer to just go straight away to the court for the purpose of asking the court to review a decision of a tax officer, because in that case the matter is really between the tax, the ATO and the individual. And for that purpose, the better way by which a complaint or a question that is raised by a taxpayer to be determined should be in the realm, for example, of the Administrative Appeals Tribunal, which can then consider the decision by the original decision maker, both on a question of law as well as a question of fact. And so, in other words, as far as tribunals are concerned, the reason why administrative tribunals are there actually, on the one hand, provides an opportunity for an individual to seek recourse with an administrative agency that belongs to the executive to try to review a decision of an administrative agency. That's one. The other aspect of tribunals is that statutes have been passed, such as in relation to the Fair Work Commission or Work Cover or the Australian Human Rights Commission or the Anti-Discrimination Commission Queensland, whereby if there are certain instances of a particular dispute or controversy or a complaint, then these are intended to be resolved by these tribunals. We call them tribunals because they're not really part of the court system. They're actually part of the executive branch. So that's a broad view. I say it's a broad view because at the level of the states, for example, and this is kind of doing a quick overview of constitutional law, that limitation doesn't exist because although at the federal level, courts are not permitted to do not have jurisdiction over cases where there is no matter. So meaning they cannot be involved in relation to questions which really pertain to administrative tribunals because of the partial separation of powers. At the level of the states, it is permissible for a court to both be a court as well as an administrative tribunal. This is the reason why you might have the Queensland Civil, which is a court, and administrative tribunal. Okay, so but the whole point there is that in relation to both courts and tribunals, these are adjudicative bodies. So the courts mainly belong to the judiciary, which is the other branch of government. Tribunals mainly belong to the executive, but both are actually adjudicative. They make adjudications. But equally, the other important point we need to remember is that they are created by statute. So there is a purpose behind the creation of courts and there is a purpose behind the creation of tribunals. I emphasize that because when we speak of conciliation, for example, what we then need to remember is that the conciliator, when a matter or a dispute is referred by the courts or administrative tribunals to a conciliator, we need to remember, therefore, that the conciliator has a dual role. One is to make sure that the conciliator discharges his functions or roles according to the statute that created the court or administrative tribunal, which referred the dispute to him or her. And at the same time, the role of the conciliator is to try to get the parties to reach an agreement. So the conciliator, therefore, is in the middle with a clear mandate to try to get the parties, on the one hand, to reach an agreement, but at the same time, there is pressure coming from the courts or administrative tribunals because of the statutes creating these bodies to get the parties to reach an agreement. So in a sense, that highlights the concern that conciliators sometimes must really emphasize the use of their power coming from the courts or administrative tribunals to get the parties to reach an agreement because there is pressure. So in general, and this is the observation coming from David Bryson in his journal article about leopards lying with the kids, that in general, when it comes to conciliation, the conciliators use their power mode. They do have the power in the sense that they go beyond just facilitating an attempt by the parties to reach an agreement, but instead there is the power to provide advice and then recommendations to the courts or the tribunals as we see. Okay, so that's clear now. The conciliation, therefore, in general, is done so within the context of a statutory and an administrative law framework. Now, from conciliation, therefore, as we see, the conciliator's role still is not determinative. The conciliator does not decide for the parties. The conciliator only makes only advises the parties, even makes a recommendation to the parties and to the courts or administrative tribunals, but the conciliation does not adjudicate or make a determination as to the dispute. That is ultimately left to the court. So from negotiation to mediation, which are mainly facilitative, it moves to an advisory approach. Away from that is arbitration, as we see. As we know, the arbitrator makes an adjudication, makes a determination as to the dispute between the parties. And ultimately, the courts, that's the function of the courts as well, to make a determination or adjudicate the matter between the parties so that there is certainty and finality in terms of the outcome. And so what this means is there as well is that in terms of the power, this is essentially empowering to the parties. Negotiation and mediation are empowering as the parties move from negotiation and mediation towards the courts, towards the adjudicative process. There is now less power to the disputants and more power to the courts, to the tribunals, the arbitrator, or the conciliator. There is a diminishing power on the part of the courts as moving there, and more power on the part of the parties as the dispute is resolved towards the left. But if the dispute moves towards the right, towards the courts, the parties lose more of their power to be able to determine what the outcome will be. Now, after having discussed the context by which conciliation often works, what I'd like to discuss is the driver of the ADR process. So as I mentioned, individuals, if they have a dispute, will often resort to negotiation or mediation for at least two reasons. One is because there is less cost when you negotiate with another. I mean, if you negotiate with a party with whom you have a dispute, there's hardly any cost there, perhaps except maybe for your time. If you engage lawyers with a negotiation, there will still be a cost, but it will be less compared to having to get your lawyer to file an application, prepare affidavits and so on, and go to court. That becomes more expensive. So as far as costs are concerned, things become more costly as you move from negotiation and mediation towards adjudication with the courts. Of course, it's different with the administrative tribunals because administrative tribunals are mainly required by law to be less costly. They're meant to be informal and inexpensive in general. But I mean, the point there is that even if it were an administrative tribunal, it becomes more complicated and probably more costly compared to negotiation and mediation in terms of the time and the emotional resources that the disputants have to invest in the process. So parties, if they want to minimize the costs and avoid adjudication, meaning avoid getting somebody to make a determination or judgment in relation to their dispute, they'd be better off just negotiating and mediating their dispute. However, if this fails, if negotiations and mediation fail, they may not have a choice but to have to go to the courts or to the administrative tribunal, depending on the nature of the dispute. And of course, the problem as they go there is that towards the courts, as I mentioned, it becomes more costly. And then the parties lose the ability to decide or to determine what the outcome will be, because they leave it to the third party to make that determination for them. The problem, however, is that in many cases, individuals tend to think that if they have a dispute and they can't get, if they can't resolve the dispute, they should go to the courts. It does make sense, but that often is not a good approach. Let's take the case of a parenting matter involving young children, for example. The problem is that sometimes parties may reach agreement by themselves through what is known as a consent order. They've negotiated, they probably entered into mediation, and then they submit a consent order to the court, which once the court approves that draft consent order, becomes the final order of the court. Or it can be that, if the parties actually went through trial concerning a parenting matter, there will still be a final order by a court in relation to the young children. The problem, however, is that in many cases, for example, in relation to parenting matters, even if there is already a final order in relation to parenting matters that have been delivered or issued by a court, there can still be conflict between the parties as to the interpretation of some of the provisions, which means that at the end of the day, notwithstanding that final order from the court, there will be claims of a contravention or claims or desires to modify parts of that final order of the court, which means that the parties then have to go back to negotiation. So that's one of the things we need to examine. But the other point is, if there is a lot of dependence on the courts and administrative tribunals to settle a dispute, then that creates a backlog in the courts and the administrative tribunals. So that what courts then do is to try to avoid this backlog, because they simply don't have the time. You can have a single magistrate which has a mention in the morning, and there could be as many as 50 or 60 cases listed for mention in a few hours. There are just too many cases that are clogging the court system. And so therefore the courts will try to shift back some of these disputes to get the parties to negotiate, order the parties to undergo mediation again, or for conciliation. Now, conciliation, again, one of the important points about conciliation is that the courts will oftentimes decide that conciliation is a better route, because the courts feel that the parties have to be advised about the law. Because sometimes when it comes to negotiation and mediation, with the diminished emphasis on the law and more on the interest, what can happen is that especially if the parties continue to be very adversarial, they may really forget about the law, or they may have varying interpretations about the law, and they don't get the issues resolved. But if they give it to a neutral third party who's an expert about the law, for example, the conciliator provides the parties an objective advice about how a judge or a tribunal member may resolve a dispute. So that almost becomes a reality check. And so therefore, from the left side here of negotiation and mediation, moving towards the right, towards the courts and administrative tribunals, yes, the effect is that there becomes a backlog in the courts and administrative tribunals, and the courts will try to, or the administrative tribunals will try to shift back some of the ways by which some of those disputes will be settled by bringing it back to conciliation. And as the parties move from negotiation and mediation towards the courts, there is a higher certainty of an outcome, because there will be an outcome if there is a case filed in court or an administrative tribunal, except that it is an outcome that the parties may not be happy with. So we've discussed the context of conciliation. We've also covered power relationships, but there is another dimension to the power relationships that I would like to emphasize, and that is the impact of the rules of natural justice. In relation to facilitative and the advisory processes, which involve negotiations and mediations and conciliation, we will notice that the independent third parties here really don't make a determination or adjudication in relation to the respective legal rights and positions of the parties. And for that reason, you will often see that you might have a mediator or conciliator or even a negotiator talking individually to the parties separately. And it might mean that in doing so, the negotiator or the mediator or the conciliator will, receive evidence, not really receive evidence, but hear the story of one of the parties without, notifying the other party. That is not a problem. There is a question about natural justice, because these third-party individuals don't make a determination. But when it comes to when you move towards arbitration and then the courts and administrative tribunals, there is a requirement for the observance of the principles of natural justice, because the arbitrator and the court system and the administrative tribunals are mainly adjudicative. They make decisions in relation to the dispute, or they decide what the outcome will be of the dispute. So there's a requirement for the observance of the rules of natural justice. Okay, now, but what do we mean by the principles of natural justice? The principles of natural justice might also be understood as being almost synonymous to what is known as the principle of procedural fairness. There are two components or aspects of the principle of natural justice. One is that the parties to a dispute must be heard. So in other words, it would be a breach of the rules of natural justice or the rules of procedural fairness if either of the parties was not heard by a judge or by a tribunal member or somebody who is adjudicating the issue. If there is a breach of the rules of natural justice, that raises a question of law and therefore potentially can invalidate a decision that is handed down, or a judgment that is handed down by an arbitrator, a court, or an administrative tribunal. So there is a requirement under one of the basic precepts of the principles of natural justice, or the rule of procedural fairness, is that the parties must be heard. The second aspect of the principle of natural justice is that the judge or the tribunal member must be impartial and objective and must not be biased. So because if somebody is going to make a determination, is going to be adjudicating a matter, that person should not have a bias, because if he were to take sides, if he were to have favorites, then it would not be fair to the other one, to the other disputant. So that would also be a breach of natural justice. And when it comes to the requirement that a judge must not be biased towards any of the disputants, the requirement is that there must be no actual bias, but there must also be no what is known as an apprehended bias, the appearance of bias. So not only must a judge be fair, but he must also appear to be fair. So an example might be that, an example of an actual bias would be that there's an actual bias when you've got a judge who happens to be a family member or a close friend of one of the litigants. That, clearly there will be a conflict of interest there, because chances are a judge who is, emotionally closer in terms of family relationships to one of the disputants is likely to favor that disputant. It's pretty common as part of, our humanity that we favor somebody that we know. But at the same time, you might have situations where a judge is pretty friendly with one of the litigants, in the sense that they may go out for coffee, or you might see that one of the lawyers is frequenting the chambers of a judge and so on. that can lead to questions about apprehended bias. There can also be questions about apprehended bias when you have a judge or tribunal member making statements that appear to or be against one of the disputants, which makes the disputant think, with this statement coming from this particular judge, he or she is probably biased against me. So judges are not permitted to do that because that may lead to claims of apprehended bias, except if it's based on the evidence. So we've covered that. Okay. Now, the other way by which we can examine conciliation in relation to the other ADR processes is that the focus typically of negotiations and mediations would be the mutual interest of the parties. It is not the legal rights or legal positions or legal interests of the parties. That is the focus of negotiation and mediation. The focus there is, if it's possible, if it were the mediator, let's avoid talking about the law for now. How could we reach a settlement? That's the purpose of the negotiation and the mediation. But as the disputants move away from negotiation and mediation towards the court system, the focus is really more on rights. And so that's one of the things that we need to remember. Now, I made this point because, as we see in the next slides, David Bryson is actually suggesting that as far as the conciliation goes, instead of the conciliator focusing on legal rights, the conciliator should attempt to focus on mutual interests as well and transcend the common tendency of conciliators to provide legal advice. So in other words, according to David Bryson, one good way by which a conciliator may reach outcomes in terms of having a settlement is to go beyond talking about legal rights, but also to consider the mutual interests of the parties. In that sense, the conciliator becomes a conciliator in the sense that the conciliator has an advisory role in relation to the legal rights of the parties, but at the same time becomes a mediator. If we look at mediator in the sense of trying to unearth and uncover the respective mutual interests that underlie the legal rights and legal positions of parties. We're going to look at that in greater detail in a short while. Okay, but let's examine first the roles of the conciliator. So, and you will notice, therefore, that as far as the lecture video is concerned, I'm not trying to repeat much of what's already in the study guide or what's in the book. The first few lecture slides have been kind of integrated in an attempt at synthesizing what we know about the different alternative dispute resolution processes so far. But let's just quickly go through the roles of the conciliator. So what typically happens as far as the conciliator is concerned is that he establishes the issues from available information. He might review the administrative practice or decision. He might question the foundation of the dispute, request further information, or choose a flexible approach. That's a typical role of the conciliator. You will notice that in doing so, the focus really is based on the legal foundation for the respective legal positions of the parties. There might be an attempt at negotiation, but that is mainly driven by a kind of a law-based approach. And then the crucial point is that, and this is missing from the roles of the negotiator or the mediator, what the conciliator can do would be to refer the dispute to an expert panel or an independent expert. He might refer it to arbitration, he might refer it to a regulatory body, he might declare a closure, issue a recommendation, both to the parties, a recommendation to the court or the tribunal, or issue a direction. So there is greater power on the part of the conciliator, as we can see, because these particular roles of the conciliator are missing in relation to the powers of the negotiator and the mediator. So these are powers that the conciliator typically has based on a statutory framework, meaning, in other words, based on the laws created at the court or an administrative tribunal or administrative agency. When there is a referral by a court or by an administrative tribunal to a conciliator, based on a statute, these roles or powers of the conciliator are typically available. Now, so the typical way by which a conciliator therefore discharges its role is the power mode. In this case, the conciliator is the leopard, very powerful position. Using the metaphor created by David Bryson in his article, "And the leopard shall lie down with a kid." So using the power mode, so in other words, if it's the power mode, it's the conciliator driving the parties towards a settlement. He's using his power. So the power actually is with the mediator, with the conciliator. The power is with the conciliator as the leopard. So as I mentioned, what the conciliator does is to establish issues from available information and assess it in terms of statutory rules or the relevant legal principles. But it is essentially law-based in terms of the framework, in terms of the lens by which a conciliator tries to examine the conflict or the dispute between the parties. He does so from the viewpoint of how he understands the law and his knowledge of the law. From there, the positions are stated concisely by the parties and are provided in a potted history by the conciliator. So in other words, the conciliator might say, okay, this is the way I understand what the history is and what I understand to be your legal positions, and this is how I understand the law to be. And then there would be opening demands from parties. The conciliator would then try to interrogate supporting information, looking for precedents for each of the parties' position. And then there's a debate and bargain in terms of legal demands. You will notice that what the conciliator does would be to use persuasion, carrots and sticks, give and take of exchange of concessions, development of new options. You notice that there is an attempt at carrots and sticks, meaning rewards and threats. The threat there is that, if you don't do this, you end up having to go, the conciliator says, I don't have a choice, but, to refer this matter to the court or the tribunal, and these are my recommendations. So there's that threat. He also uses persuasion. Now, when it comes, therefore, to persuasion and carrots and sticks, these are approaches that a mediator will never do or cannot do. The mediator, going back to the point about mediators really just facilitate a discussion of the parties. The power still lies with the parties. It's difficult for a mediator to try to persuade any of the parties to reach an agreement, because that puts a mediator in a tenuous position. It could be argued by any of the parties that they were coerced into reaching an agreement. That might mean that there'll be questions about the validity of a settlement agreement if it was done through coercion. But it's pretty acceptable for a conciliator to try to push the parties to reach an agreement. Now, eventually, if they succeed, then they work out an agreement by emergence of mutually prominent solutions based on compromise, or accept something is better than nothing, or find a creative solution that is more desirable than a compromise, or a non-binding agreement open to further negotiations. And later on we'll see the Masters versus Cameron agreement in one of the legal issues. But just quickly, when we talk about letter D, for example, a non-binding agreement open to further negotiations, what can happen is that there is kind of an agreement between the parties, but that agreement can often mean that there is that's an agreement that is conditional upon some other event happening or some other agreement being done. Okay, so that's the power mode. David Bryson suggests that conciliators ought to consider an empowerment mode, and that's the conciliator as the kid. So here, the role of the conciliator is to establish the issues and construct an agenda based on party perceptions and interests. Now, there is there is emphasis on the perceptions, the different realities of each party and their respective interests, rather than legal positions. Here, the conciliator focuses on interests rather than positions, discover interests based behind positions and issues. The parties communicate and understand each other's interests, what is sometimes known as mirroring, and identify commonalities and differences. And then there's determination of an objective criteria to be used for negotiation. What you will notice from this particular framework suggested by David Bryson, this actually follows the interest-based negotiation approach of Professor Roger Fisher, and William Urey. And so therefore, the suggestion of David Bryson is mainly that instead of the conciliator adopting a power mode where he is really driving the parties towards a settlement by using, by focusing on the law and legal positions, Bryson is suggesting that the conciliator doesn't have to be the leopard, he can be the kid. And in that case, bring back to the parties the power for them to reach a settlement by focusing on their interests rather than the legal rights or legal positions. Now, one of the cautions there, one of the warnings is that, remember, as we said, that the conciliator has kind of a difficult position in the sense that on the one hand, the conciliator wants to have the parties reach an agreement that both are happy with or that the parties are happy with. But at the same time, the conciliator actually is working on the basis of certain statutory and administrative law expectations. So the conciliator is aware that the court or the administrative tribunal is expecting the conciliator to use some of the power that is with him to advise the parties about the law for them to reach an agreement using, the carrot and the stick, with the threat that, if you don't reach settlement, this is the way the court or the administrative tribunal will reach a decision. So in a sense, when we speak of the empower mode in conciliation, the suggestion of Bryson essentially is that the conciliator takes in the role of a mediator and in a sense gives up the power that is given to him by the courts. Now, we don't really know if that is necessarily effective. It might be effective, of course, in the sense that it may be better for the conciliator really to push the parties towards reaching a settlement on the basis of consideration both of what the law is and what their respective interests really are. But that's just an approach that is suggested by David Bryson. And so there we go. On completing this, after watching this this lecture video, you should be able to discuss and explain the process of conciliation, the similarities and differences between conciliation and other types of ADR, the role of the conciliator, and the uses of the conciliation process. And with that, I thank you for watching this lecture video. Bye.